Good morning, class. Today we are on week 3, and we are going to continue on the topic of copyrights in the internet. Okay. Last week we looked at the various types of copyright work and the statutory rights of the copyright owner. All right. And today we are going to look at the exclusive rights of the copyright owner in the context of online environment, and how infringement can take place in the online environment of copyrighted work. Okay, the first one, we're going to look again at the right to reproduce the copyrighted work, right? So in this case, usually you look at online environment and you look at copyright infringement in the context of online environment, it usually takes place when data is being transferred from one computer to another. Okay, so just remember that the right to reproduce any work that is copyrighted belongs to the owner. So when data is being transferred from one medium, could be a computer, to another, okay, there is a potential probability that copyright infringement can take place because you are infringing the right to reproduce the copyrighted work. Okay, now, so if you look at, there are two cases. One is Apple Computer versus Formula International, and the other is MAI Systems Corporation versus Peak Computer. Okay, so we look at these two cases. The first case, you look at copies that were stored in the RAM, all right, and because that these copies were stored in a temporary basis, all right, and the running of that, a computer program from the RAM uh, was decided by the court not to, have created an infringed copy. All right. So again, because it was stored in a temporary, file, right? So you find that the copies stored were in the RAM, were on the basis of temporary, so not permanent, right? So therefore the court said that the computer program that was running from the RAM, okay, did not create an infringed copy. In the case of My Systems Corporation versus Peak Computer, however, the court came up with a different decision. Okay, now what happened was this software was downloaded into the RAM, right? And whenever the defendant turned on the computer, he could actually see the software program, and he could actually use the software program to diagnose the problem while performing maintenance. All right. So the court said, look, every time he switched on the computer, he could access the software program. So it was sufficiently permanent and fixed. Okay, so it's not in the temporary, part of the computer. It was, sufficiently uh, in a permanent form, in a fixed form to constitute infringement, right, of the software, right? And the main reason is because every time he switched on the computer, he could access it and he could run the program. So it was in a sufficiently permanent form for that work to be a infringed work. Okay, and therefore the right to reproduce, uh, the statutory right to reproduce, has been violated. Okay, so these are the two cases. You can see it all depends on whether it is stored in a temporary form or in a permanent form where they can access it regularly, right? So therefore, you can come up with the principle that an unauthorized downloading of software onto RAM and using it for personal gain can constitute both copying and also infringement. Okay, so we have to be very careful when we are downloading software, especially if there's no license to it, right? It could be considered as unlawful because it is, copying as well as infringement of the statutory right of the copyright owner to reproduce the copyright work. Okay, so that's the two cases. Okay, we'll go to the next, which is on the right of distribution. So another right of the copyright owner is to distribute it to the public, distribute copies to the public, right? And this includes other interests, proprietary interests, right? Such as selling, renting, leasing, okay? All of these things are relating to, giving copies to the public, right? So when you download unauthorized photographs, all right, you can actually look at the platform that is being used to unload these unauthorized photographs. And normally, usually when you download it into a bulletin board system, all right, you can be considered as having infringed the right of distribution, right? So if you look at the case here, Playboy Enter Incorporated versus Freener, okay, the court held that when unauthorized photographs of Playboy Enterprise were downloaded to a bulletin board system, right, by the defendant's subscribers, the plaintiff's exclusive right of distribution was infringed by the customers of the defendant. The bulletin board operator, right, had an obligation to monitor its system to ensure that the copyrighted documents are not displayed and downloaded by its customers. So actually, the bulletin board operator is the contributory infringer. Yeah, we are going to learn that in a while, but they have contributed to the infringement of the right of the copyright owner by providing a bulletin board system where the subscribers was able to use their system to download the unauthorized photographs. Okay, so the court here said that basically the subscribers had infringed the copyright of Playboy Enter Incorporated. And of course, in this case, the bulletin board operator had the responsibility of monitoring the system and they didn't do it properly. So they have actually contributed to the infringement of the subscribers. Okay, so they are contributory infringers, whereas the subscribers are the primary infringers. All right. Now let's look at the next case, all right, where you distribute emails, okay, without permission, or you attach, emails and you forward it without permission of the owner, right? So in this case, Marobi, Florida Incorporated versus National Association of Fire Equipment Distributors, the court held that the electronic clip art files, which was then placed, the unauthorized copies of the plaintiff's electronic clip art files, when it was placed in the defendant's web page, it had constituted infringing distribution, okay, because the files were available for downloading by the internet users, right? So here again, you can see web designers and managers should be very careful, right, when they actually include any form of clip art on their what do you call it, they make available these clip art files, which are then attached to the web page, right? And if they were done without getting the permission of the owner of the clip art, then you are actually committing copyright infringement. Okay, another example, linking. All right, as you know, sometimes one web page will link, the URL of another, right, website. All right, and that too can potentially cause, what do you call it, problems. All right, uh, but here, if you can look at it, linking to a website, all right, by listing its URL is similar to giving directions to the listed site, and it's not copying within the Copyright Act, or it's not copying. Remember, it could be copying, it could be also infringement, right? So in this case, that's not copying when you actually link, right? However, if you say the linked website have got a lot of infringing copyright material, right? Then you can potentially be liable for copyright infringement, right? Just the mere linking is not, like if you put the link of another website, that's not copying. But by clicking and you go to the other website, and if the other website has got infringing copies, then it could be problematic. Okay, now we're going to again look at the right of distribution, all right? Continuing with databases. Okay, now if you know, when you look at any kind of compilation of data, that is also subject to copyright, right? Now, so for example, if you took a phone book, right, and then you pulled out certain numbers in a certain, pattern, right, that has, copyright protection, right? Because you are creatively selecting and arranging the data. Right? So sometimes you can see that these databases, they are also protected by copyright, protection. Copyright protection. Yes, that's right. So it's very important to make sure that when you actually obtain information from databases, that you are getting the permission of the author, right? Now, there are several cases. The first case is Vice Publications Incorporated versus Rural Telephone Services Incorporated. All right. Here, the court did not give copyright protection to the publisher of the telephone directory. And their reason was, they said, the mere alphabetical listing of names and telephone numbers did not have originality. There was nothing creative about arranging names and numbers alphabetically. They just took it like that and just put it there. There was no, nothing different in the way they had arranged it. So therefore, they were not entitled to copyright protection. So basically what this case is saying is, when you take information from one database and you put it in another form, you can't just simply take it and then put it there without any changes made, then you will not get copyright protection. However, if you use some kind of creativity and you arrange it in a very different way based on certain scheme that you have, then that will be entitled to copyright protection. Now, let's go to the next case, CCC Information Services Incorporated versus McAllen Hunter Market Reports Incorporated. And this involved an online case about a red book, all right? And basically it put together a list of used automobiles, all right? And then it gave the retail value of those automobiles, right? Now, the court held that the book would be granted copyright protection because the listings, the way they had listed it, it was not something that is like copied outright from another source. There was some form of creative effort in doing the listings and also giving the retail value of the used automobiles. So this book was found to be original, together with the listings, the way it was done. So therefore, the court said that it the book would get copyright protection. So in essence, we can summarize from these cases, there must be some kind of original coordination of the data and the arrangement of the data presented in the online environment. So that means they must have done something creative, or there's some creative effort on the part of the author in the online environment, and that will entitle the copyright owner to get copyright protection. Okay. Now, next is on the right to prepare derivative works based on copyright works. So basically, I explained in the previous lectures what is a derivative work. It is a work that is derived from the original copyright work. Right? So when it is derived from an original copyright work into another form, all right, that would be a derivative work. So the example I gave is, remember, this novel, right? The novel is now produced into a movie. So the movie is a derivative work of the novel, right? So, or a particular novel is translated into another language. Now that would become the derivative work. The translation would be a derivative work, right? So these are examples of derivative works. Right? So when we come to web designers, right? So normally, right, when you want to design a web, okay, they usually look at other websites and then they will see what are the attractive features or unique features, right? And then they will try to see how to come up with their own web design. But you have to be very careful that you don't infringe the copyright of another website, all right? By preparing a derivative work, that means you derive your website from the features of another website, all right? And so then you can potentially infringe the copyright of the other website. What kind of copyright infringement? The copyright infringement of the owner to whose right to prepare to come up with a derivative work of the original work, derivative work from the original copyright. Okay, so now if you look at, there are this case of Louis Gallup Toys Incorporated versus Nintendo. The federal court held that the game Genie device that altered features in Nintendo's video game cartridges did not create a derivative work. It merely enhanced the audiovisual displays without incorporating any underlying work in permanent form. So here the court said the work that that was created in the game Genie, all right, uh, which actually had enhanced the audiovisual displays, but didn't actually incorporate any of the work in the Nintendo, was not actually a derivative work, right? So therefore, they didn't really, create a derivative work from the Nintendo's, video game cartridge. Okay, so therefore, it did not infringe the right of the copyright owner to prepare a derivative work based on an original copyright work. Okay, now, so basically, what's the solution to protect yourself if you are an e-business? All right, what you should do is you should have an indemnity contract with the website designer, right, that will repay them for any potential liability arising from copyright infringement suit based upon derivative work. So basically, right, you should create a contract with the website designer, right? And basically, if there's any potential liability, then you are going to repay the damages that is arising because of the liability from the infringing the derivative works. Okay, so normally when you create any website, all right, you have to be careful that you do not infringe the right of the copyright owner to produce derivative works. And one way to protect yourself is to actually prepare an indemnity contract whereby you indemnify the website designer for any liability they will incur, right, based on the derivative works. Okay, now the next right is related to the right to perform and display publicly a copyright work, right? So if you look at the right for public performances, all right, whenever a particular copyrighted work is either, open to the public or played to the public, right, then you are potentially running the risk of, infringing the copyright owners to perform the right of the copyright owner to perform and display publicly a copyrighted work. All right. Now, so what is a public, or when do you consider it to be a public? Right. It's basically when there's a lot of people gathered, and they are, in a same place at a particular time. Then you can consider that it is actually public, right? As opposed to like you looking at a movie, right, and in a house where just your family members, that's not considered to be public, right? So it's like assortment of people gathered in a place that will be considered to be public. Right, now if you look at the case Columbia Pictures, right, versus Aveco Incorporated, the defendant had improperly authorized public performances by renting videotapes and allowed customers to see tapes in viewing rooms. So basically, he actually allowed these, what do you call it, tapes to be played in the viewing rooms, all right? And the court held that this was a place open to the public within Section 101 Copyright Act, and this was actually infringing the right of the copyright owner to perform and display publicly a copyrighted work, right? Now, similarly, the display of web material by managers on employee training programs without the consent of the owner can also constitute an infringement of the copyright owner's right to perform and display publicly a copyright work. So sometimes in training programs, you will show web materials, you will show videos, you will show all of that. That too, when you do it without the consent of the owner, can potentially be a copyright violation. Okay. Now, in case Michaels versus Internet Entertainment Group Incorporated, right, it was held that making available videotape over the internet without authorization, and not only did they, make it available on the internet, but they also posted unauthorized copies of the electronic clip art on web pages. Again, violated the copyright owner's right of public display, right? So these were example of cases where, basically when you look at these cases, a lot of the times we do these things, we upload, other people's art or clip art or, tapes, musics, and so on. We upload onto websites without actually, getting the permission of the copyright owner. Right. It had actually happened. This is not really in the case of internet, but in Malaysia, um, where like some of these music was actually played in factories, to encourage, like when factory workers are working, they play music, so that it won't be so monotonous. And the singer actually found out that this music was being, you know played in this factory settings, right? without obtaining permission, and actually they sued and they won damages in court. So these are examples. Sometimes we do these things without really thinking about it, but actually you are violating the copyright owner's exclusive statutory right. Um, okay, now coming back to what are the different types of copyright infringement, right? I explained earlier, you could be doing direct infringement. Remember the case earlier where clip art was no, actually it was the what do you call it? Certain photographs were actually downloaded to the bulletin board, and the subscribers were using the bulletin board service to do so, and that the subscribers were committing direct infringement. The bulletin board services were actually doing contributory infringement. So basically, when you talk about infringement, infringement can take place in three different ways according to the theories. The first is direct infringement, the other is contributory infringement, and the third is vicarious infringement. So I will go through these three, all right? Direct infringement meaning you are the primary person committing the infringement, just like the earlier case where the subscribers downloaded the photos, right, in the bulletin board, right? So they are the direct infringers. They're actually infringing. They are the direct actors or the primary actors committing the infringement. All right. And because Copyright Act is a strict liability statute, you do not have to prove in court that the person knew about it or the person had intended to commit infringement. So you don't have to actually show the intent, right? Because it's a strict liability statute, right? So just the fact of downloading itself will actually expose you to a liability. All right. Now, so that is, in terms of direct infringement, the court doesn't have to prove that you had the intent to infringe. They don't have to do that. The fact that you downloaded itself shows that you are going to be liable for copyright infringement because they're going to presume that you had the intent to infringe, right? Now, so the case earlier, right? The Playboy Enters Incorporated versus Fern, right? The one that we discussed earlier. The court found that bulletin board operators liable for direct infringement for the unauthorized distribution and display of images uploaded to and downloaded from their systems, even though they did not make the copies themselves. Element of causation was present here, right? So here, in that case, not they were also considered to be the direct infringers, right? I mean, normally, in many cases, these would be service providers. They would be the secondary infringers or contributory infringers. But in this case, apparently, they were actually found to be also direct infringers, all right, for the unauthorized distribution and display of images uploaded to and downloaded from their systems, even though they themselves did not make the copies, all right, but they caused the copying to take place through their bulletin board services. So because the element of causation was there, right, they were considered to be also direct infringers. Interesting, right? Now let's look at this case, contributory infringement. Right, that means you are allowing another person to cause direct infringement right now. So if you know that you are allowing another person to infringe, right? And if you are allowing direct infringement to be committed by another person, that's why I said earlier the bulletin board services can also be found to be contributory infringers. But in the earlier case, the court said they were also direct infringers. But you can see why they would be also potentially liable for contributory infringement because you have the knowledge and you are causing, right? the person to commit direct infringement by providing the bulletin board service, for example, right? And therefore you can be a contributory infringer. Okay, so if you look at the case, Sega Enterprise Limited versus Mafia case, it's a leading e-commerce case where the court did not find direct copyright infringement by the operator of the electronic bulletin board service, but found him to be liable for contributory infringement. So quite interesting, isn't it? In Sega Enterprise versus Mafia case, they said that the bulletin board service was liable for contributory infringement, but in Playboy Enters Incorporated versus Fern, same thing, bulletin board service, but they found them guilty for direct infringement, right? So you can see the courts came up with different decisions in both these cases, right? So therefore, as an e-business manager, you have to be very careful that if your subordinates or people who are working for you in the company, uh, could what do you call it? Be committing direct infringement, and what do you call it? And the company then becomes liable for contributory infringement. So that means if your employees are doing direct infringement, then the company can become indirectly liable for contributory infringement. Okay, because you are actually allowing your employees to do these, copyright infringement by through email, company email. So therefore, your company can become liable for contributory infringement. Okay. Now, the third theory is vicarious infringement. So, what's the meaning of vicarious? Vicarious basically means that you are liable through another person's copyright infringement, right? So, if you look at the case of a company, if the company gets some form of direct financial benefit from the infringement of another party, all right, and had the right and ability to supervise the infringement activity, then there is vicarious infringement, right? So it doesn't matter that you didn't know about it, nor did you participate in it. The court doesn't take into account whether you the company, knew about it, nor whether you participated in it. They're not going to take into account those things. The important thing is you are getting some kind of direct financial benefit because of that direct infringement. That's all that is needed. All right. So, by virtue of the fact that you get direct financial benefit from some form of activity of another party, that usually is through your employees, all right, then you can become um, uh, liable for what you call vicarious infringement, right? Another example of vicarious liability is, say, for example, mm, a doctor performs surgery and something goes wrong because of his negligence. The doctor is, what do you call it? Of course, he's liable because it's through his act that that the surgery had created, what do you call it, some form of damages to the patient. So definitely the doctor is directly liable. But the hospital who has hired the doctor is vicariously liable. All right. So because the hospital also benefits, obtains financial benefit from the fees of the operation, surgery, and so on and so forth. So, because the hospital has direct financial benefit, the hospital becomes vicariously liable. That's an example of vicarious liability. So, similarly, copyright infringement, you can become vicariously liable through this third category of liability. All right. So, so that is, something to be careful for, right? Okay, now, so in the case of Religious Technology Center versus Netcom online communication services, what did you see? The court here did not want to, make a decision saying that there was vicarious liability against the internet provider because the plaintiff could not prove that there was some kind of direct financial benefit received by the internet provider from posting the infringed material. So, because the plaintiff could not prove that, the court did not say or court did not decide that there was vicarious infringement. So, as you can see, for vicarious infringement, it's very important to prove that there was some form of direct financial benefit. Okay? All right. Now, we also need to look at limitations of copyright owners' exclusive rights. So you can see the copyright owner has got various exclusive rights, but in certain circumstances, these exclusive rights have got limitations. All right. Now, what are these limitations? There are several. All right. One is called fair use. Second is called the first sale doctrine. Third is called public domain use. And there are also other statutory exemptions. Statutory exemption meaning exemptions provided under the Act, right? So let's look at each one of these. One is called fair use. They call it the fair use doctrine. So basically, fair use is actually a public interest argument, all right? And basically, this public interest places limitation on the exclusive rights of the copyright owner. And so sometimes, if the plaintiff sues the defendant can argue that he was using that particular right through fair use, right? Now, it's basically allowed under the law, and it is actually a legitimate defense in any cases brought against you. You can argue that it was fair use, right? Now, there are certain factors that will determine whether it was fair use or not. The first is whether it is a commercial or educational nature, the use. So, for example, universities, we use a lot of copyrighted material. And if we are sued, we can say that we're using it for educational purposes. All right. So then and we can argue fair use, because if it is not commercial, if it's educational in nature, then we can argue fair use. All right. So the other is the nature of copyright material. Is it merely informational or is it factual? Right. Okay. So if it is merely informational, right, or factual, right, then you can, argue fair use. The next thing that they look at for fair use is the amount that of the how much you have copied, right? Uh, is it you're using the whole, information, everything in that copyright material, or a large part of the copyright material was copied, or just only some parts of it. So they're going to look at that, right? And if it's only some parts of it, then not a lot, just a certain amount only, then you can argue fair use, right? And then finally, they're going to use the criteria of impact. Okay, what is the impact of the use on the market value of the copyright material? Which is why when students actually copy textbooks, the whole textbooks, right? You have actually copied a significant amount, or the whole textbook. When you copy, you are actually copying all of it, and definitely that is going to affect the value of that copyright material, right? Because if a lot of people are allowed to actually copy all of the book, nobody is going to buy the book. So definitely that is going to actually impact on the market value of that book. So definitely that would be a no-no, right? So you cannot argue fair use in that context. First sale doctrine, right? So an example is, for example, if you bought a book, right? Then you bought it, like you paid money, you bought it, right? Then you have lawfully acquired it. Now you have ownership over it. Then you're allowed to sell that book, say secondhand, right? After using it, right? So that's called the first sale doctrine. Again, this first sale doctrine limits the copyright owner's exclusive right to distribute publicly a copy of the work. All right. So because the book was lawfully acquired by another, right, you can actually sell it, right? Because you were the first person to acquire the right by buying it for sale, and then you sell it again, right? So that's called the first sale doctrine. But the sale, rental, or lease of a licensed computer program without the permission of copyright. So even though you have legitimately acquired, software, for example, right, or a computer program, you cannot actually distribute it or make copies of it without the permission of a copyright owner because it may constitute an infringement. Public domain use. Okay, what is public domain use? That means the material is in public domain, right? Now, normally, if the materials are in public domain, it is no more under the exclusive statutory right of the copyright owner. And this falls into two categories: all works of government, all right, all these parliamentary records, court decisions, statutes, all of that are works of the government, all right. That comes under public domain and therefore does not have copyright protection. The other is when the copyright term has expired. So you remember a life plus 50 years. So after life plus 50 years, the copyright work goes into public domain and therefore is no more eligible for copyright protection. So that is public domain use. So you're using works that are already in the public domain, and that is a limitation of the copyright owner's exclusive right because the term of protection has expired, right? Or it belongs to government kind of works. Right? So there would be other, right, exemptions, all right? Um, Owner of a copy may make copy as an essential step in using the program and may make limited copies of that program unless prohibited by the terms of the license. So for example, if I buy a particular or I download and purchase a particular software and it allows me to install it in say 3 of my computers, all right, that is what you call it, allowed, right? Exempted. You can make the copies, right? Because the license allows you to do so. But sometimes the license says you can only install it in one computer. So if you make copies, then you are infringing the rights of the owner, right? So again, depends on the license agreement. Okay. All right. Finally, if you have committed copyright infringement or somebody has infringed your copyright, what kind of remedies can you get? The first is called monetary damages. That means in terms of money. You can get damages in terms of certain amount that you claim uh, from the losses that you have suffered, right? In the form of money, all right? So that would be monetary damages. The other is called statutory damages, meaning the act will say if you have committed this infringement, then the statute will allow you to claim for damages for X amount, all right? And that's called statutory damages. Then you have got lawyers' fees. That means you can also claim for legal costs because if you are going to bring a case in court, you have to hire lawyers. So if you win the case, you can include among the claim the legal costs that you had to pay to bring the case to court. So you can claim that as well. So that's called legal costs or lawyers' fees. And then another remedy available is what you call a preliminary injunction. If you find out that somebody is infringing your copyright, if you wait till the case is heard, the losses you're going to suffer is going to increase. So while waiting for the court to hear your case, you can apply for a preliminary injunction, which prevents that person from using that copyrighted work until the case is heard. Right? So injunction is actually an order that prevents the person from doing an act, and in this case, an act that is considered as a copyright infringement, right? Now, so but if you win the case, right, that preliminary injunction, if you're successful, will become a permanent injunction, right? So that is another remedy available, right? Or you can also call it as a temporary restraining order. You're temporarily restraining the other person from continuing with the infringing act, right? So these are the remedies that are normally available for copyright infringement. Okay, now what I would like you all to do is actually to look at the chapters that I have actually uploaded for you, all right? And that, in the few chapters that I've uploaded for you in this one document, right? And I want you to look at that for copyright infringement. That would, help you to understand a little bit more in detail. And also, I would like you to go to the end of the chapter of copyrights, okay, chapter 4, and you will see there are questions at the end. And I would like all of you to try to, answer those questions, all right? If you remember, usually at the end, they've got a few cases, all right? Let me just show it to you, all right? Let's see, okay. Okay. All right. So you have these case problems, right? 1, 2, 3, and 4. All right. So there are 4 cases here. And what I would like you all to do is basically try these questions, because these will actually, remember I told you, these questions will become your questions for your tests, right? So you already have advanced notice of what these questions are. So just try to practice these questions, and then perhaps I'm thinking of doing an online session on Thursday. I haven't confirmed it yet, so we can actually have certain discussions then. All right, but even if we didn't, I would like you all to try these questions. And then when I have the test, you will know that it's going to come from some of these questions here, right? Anyway, thank you very much. I'll stop here for now. And I will see you on Thursday. Thank you.